I'm Jennifer Novak. I'm a California lawyer who specializes in California environmental law. Our firm helps property owners, developers, and businesses understand their legal obligations, and we represent them in administrative and judicial enforcement cases. One question that comes up from time to time is whether it's worth agreeing to perform certain investigation work voluntarily or whether to force a government agency's hand and make them issue an enforcement order. So let me offer a few thoughts. I think there's a time and a place for getting testy and for putting your foot down with government agencies. Spoiler alert, from the minute I start working on a matter, I'm already trying to identify where I think the agency is inflating its data and information, where it's overreaching, and I'm identifying the line between where I think the agency is supported by the science and the law and where I think it's going too far. So from day one, I'm already thinking about how a court is going to look at a situation. But here's the problem. State and federal agencies are charged with protecting the public. The laws are written to give them power and authority to look into situations where there may be environmental or public health concerns. And unlike your usual lawsuit, their burden of how much information they need to investigate is really low. So unless you have no connection to the targeted property or business, or it's some other rare circumstance, chances are you're going to have to do at least some minimal level of work. Now, the dilemma is that when a business voluntarily agrees to undertake certain work, they often reach a point where it feels like an endless process. They propose work, they negotiate a scope of work, they do the work, and then the agency still has questions. And for that reason, we see people either want to avoid that situation entirely, or they need some hand-holding to help them identify the right point in time to be able to say, okay, enough. Now, the benefit of doing this voluntarily is that you have some control over the process. You can propose a scope of work that provides the agency the information it seeks, but it doesn't go overboard. Or you may design the scope in a way to also help develop evidence that you or your property isn't a risk. On the other hand, if you wait for the agency to order you to do something, you're likely to see it written in the most conservative terms possible. Even if the agency is just interested in, say, soil vapor, you might see them ask for investigation of vapor and soil and groundwater. They may ask for more wells than is really necessary. They may ask you to work for a longer period of time than they really need. So then there's the choice. Do you sue them because this order is overbroad, even though there's a really good chance a court's going to uphold at least some portion of it? Or do you cross your fingers and hope that just because the agency has leverage over you, they can enforce this order, they'll still be reasonable and let you do a more reasonable scope of work? Look, every situation is different, but before you decide whether to volunteer or to wait for an agency to issue an order, you should get advice about the risks and benefits of your options. We've helped lots of businesses make these decisions, and we would love to help you.